Well, I'm thinking a lot of things now after everybody's saying things, but I won't jump in. We'll hear from John first. John Diaz is editorial page editor for the San Francisco Chronicle, and when you took up this issue years ago, and I think it could be safe to say that there has been some reform that's come from the work that you guys have done, but I'll let you tell more about that. Thanks, John.
Thank you very much, Daniel, and thank all of you for being here of an issue that's of great importance, I think, to the state, and it's been really a focus of our editorial page since 2005, when we really took up the foster care issue. And the reason that we did is first of all, it seemed like every year or two I would get some voluminous report on what's wrong with the foster care system, and it would have a lot of statistics and really not a lot of insight as to what's wrong. And the other reason that I really wanted us to look and concentrate on foster care is when I think about the failings of the foster care systems, they are directly intertwined with some of the major issues that we were looking at generally in society. You look at homelessness, you look at the prison system, and then the percentage of inmates who had been in foster care. You look at education and sort of the struggle that we have to have young people really equipped to compete in this local economy. And they all go back to foster care. And then there's the overlay of that, and the reason that I really felt passionate about this issue is looking at it as a parent. If you look at these statistics of what they call outcomes in the foster care system, I think any one of us as a parent, if we looked at those percentages, like there was a 2% chance that our child would graduate from college, a 25% that they would be incarcerated within the first few years of leaving home, it would be your first, second, and third priority in life. So we really set out to really do an intensive look at the foster care system. I would say since 2005, we've written hundreds of editorials, I've written some personal columns, and apropos today's subject in dependency courts, I thought of the package of stories that we did in 2005 and 2006, which I think did have some impact in terms of the state legislation to not only reform the foster care system, but to put more resources in it. I thought the most revealing story was when one of our editorial writers, Patty Poblete, was able to persuade a Santa Clara County judge, Leonard Edwards, to let her in and to detail everything that went on in that juvenile dependency courtroom that day. And here are some of the takeaways. And if you look at the story that she did, which had a lot of detail, there were no constraints. Obviously, we were not going to name any of the children or give away personally identifying information. But here are the things that you don't necessarily, that kind of get lost in the blur of statistics, is this judge made 20 life-changing decisions in a single day. And we were able to look at not only the decisions that he made and the magnitude of, do I take this child away from their parents, et cetera, but also how relatively little information that he had in front of him, besides obviously he had a written report, but sometimes in very succinct hearings had to make these snap judgments. I think that helped instruct our editorials on the need to reduce the caseload, to give more resources to courts. We described some of the cases in really poignant detail. There was one where there was a young woman who was a child of Mexican immigrant parents, and not only she was not in the courtroom, her parents were not in the courtroom. And basically this judge was making a decision without her even there. And at that time, it was not required by California law that a child even had a right to be in a courtroom for these life-saving decisions. Needless to say, that led to some editorials that we really emphasize, and today it is law. Another takeaway that we had as Patty documented what was going on in that courtroom is that these dependency courts should be open. and that the public should have a right to see what's going on, for better and for worse. I think if you read that story, that editorial that Patty wrote, it wasn't a case of necessarily good people and bad people, competence or incompetence, but of a system that was very much overwhelmed and really needed to have more consideration of the children. And in fact, I think it did make a difference. And certainly we since have been strong advocates for open courtrooms. We strongly supported AB 73. I have a great deal of respect for Fostering Youth Connections and the work that they've done in advocacy for foster youth in Sacramento. I just respectfully disagree, because I think that transparency, as Judge Nash says, can really be critical to having people understand what's going on. And I found it instructive that if you look at the opponents and opponents of AB 73, which was to create a pilot program, you notice that one of the opposition was the union representing the social workers, as if I found that rather instructive. As we said in our editorial, the children deserve privacy. The adults who are in charge of deciding their fate, the judges, the social workers, the lawyers, do not. For better or for worse, we need to see what's going on there. And in terms of sensitivity, I can tell you, if you look at our coverage, we have had great access to emancipated foster youth. I hate that term, by the way. If you look at what happens to young people when they leave the foster care system, I think emancipated is the absolute worst word, most inappropriate you could use. But we had really good access to talking with former foster youth about what happened in their experience. But when they talked about what happened when they were in foster care, by definition, that information was several years old. We need to know. This state several years ago made a really concerted effort for reform. All the politicians went up in Sacramento and declared victory. Look at everything we've done for foster youth. Governor Schwarzenegger had the signing ceremony. We need to see what's going on now for the youth who are in foster care now, and really the only way to do it is to be in there in the courtroom where those life-changing decisions are being made. Thank you.
Thank you very much. We're going to get everybody to sit up here, because I think that we're going to have a lot of questions. So I think that'll be the best. And I've got this mechanical thing that goes down amazingly. But thank you guys all very much. I think it's very helpful.
Great.
Don't slide down. Is that enough? All right. Let's see. Thank you very much. Barry, what are we going to do? God, this is this is a very dangerous situation. We might lose an editor here.
We got plenty.
You okay? Yeah. Okay. So, I think that we got a very packed little group up here, and I'm just, I would imagine some people have some questions about certain things. We've heard both sides. I think this is more, we talk about, Judge Nash talked about, and Jamie talked about legitimate interest that you need to have to be able to gain access to courts. I'm really thinking about journalists that think about in terms of best interest of the children always, and I'm wondering if that can be a standard for admittance. I don't know, but I'd love to hear from folks in the audience. I know that there's a lot of varying decisions, varying opinions on this thing. So does anybody want to jump in? Edward.
Aren't there many other kind of court proceedings and non-court proceedings where publicity for an issue in general has been good for the procedure, even though the publicity is bad for many of the individuals who are involved?
Yeah, okay.
I think I don't necessarily believe that there has to be a negative for the individuals in it. I don't think that there has to be a negative for the courtroom that's looked at or the youth in that courtroom. If we provide enough ethical protections and that journalists really are held accountable by their papers and by this kind of signing on to a system, or by judges like Judge Nash, making sure that they're held accountable. I don't necessarily believe that those individual youth are negatively impacted, but I do agree with you that you can have tremendous change when there is light and there is this, the impact on one can impact many. As we talked about earlier, I think there's an assumption that on both sides that is made. One is the assumption that shedding light makes change, and the other is that showing light won't make a difference. I think that your argument about an individual case is important for making a difference across the board, because people don't know the issues that affect foster youth. A lot of us in this room are obsessed with the issues that affect foster youth. We know in detail what AB 12 is, and we know about healthcare needs of foster youth and the court systems being overrun. But Lonnie Hancock, who I worked for when she was in the assembly, had no idea of these issues. And then I had to talk to her, and because she was a normal citizen, and then she was a politician. But what do people have in terms of knowledge on these issues if they're not working in these systems? They have false news coverage, not news coverage. They have false movies and stories. We have Harry Potter, which is great, but not what all foster youth go through. And we have Superman. He's pretty cool. But having news coverage on these issues can be helpful, because there are staffers that are normal people and then they become staffers, and there are politicians that are normal people and then they become politicians, and they're writing these laws, and as much as we want them to all be knowledgeable on all of these issues, they aren't. And so there can be a positive repercussions for showing what's going on in individual cases.
But isn't there, and I'll hand this over to you, Chantal, but isn't there a very high degree of danger, right? I mean, if there's a case where a child has undergone sexual abuse, and that is now splayed across the pages, and that gets out in the school, that's not something that journalists can take back, and that's not something a journalist is accountable for. So I think that, that's what we're weighing, is that danger on the other side. So I don't know, Chantal, if that helps. I don't know what you were going to say, but I just wanted to put that out there.
I don't know what I was going to say either. Well, I think that goes kind of precisely to the point. I think that the other side, I do disagree that I think most stories about children and youth in foster care have been on impact negative, and I don't know that, and I think the reason for that is that newspapers have to sell, and they want, and the good people want to tell the true stories, and the stories that come across their desk are people that are complaining about the system. It's not generally people that want to praise their good social worker or people that want to praise the work that their attorney did. It's generally people who, parents and social workers or members of the public, that are upset with the system. And so I think that it's no fault of the media, but that's just how it has been portrayed. I do think that that's kind of what the youth are weighing. The youth are weighing that, that yes, there is probably some good that will come from the media being open. I think that the arguments that came to the youth were, look, you guys are in a situation where the system isn't funded enough. The system doesn't have enough social workers. The system doesn't have enough attorneys. So unless we shed light on this issue, then nothing is going to change, because we know all of that and nothing has changed about that. And I think that is correct. But what the youth were not willing to do is say, well, it's your job to tell your bad story on behalf of all of us to change the system.
Just a thought. First of all, I've been in the news business 35 years, so I'm the last person who's going to say that everything that we do has a good result or a happy ending, because I realize not only do you have responsible journalists and irresponsible journalists, but you have responsible, dedicated journalists who are doing the best that they can, and through, for whatever reason, it has a consequence that comes out bad. But I do think, in terms of transparency, in terms of sensitivity, this is something that we've dealt with immensely in the last few years as we looked at foster care. I do agree with Chantel. A lot of if you looked at the preponderance of our coverage, you would say, wow, the San Francisco Chronicle has a pretty negative view of the foster care system. And I would say, yes, I think the system has failed in many cases. And I thought it was very important, and this is why it's important to get into those courtroom and to see those individual cases, is you have to tell the story of the human condition but individually to really get people engaged. And you can talk about the statistics all you want, and people are not necessarily going to identify with the young people who are in that system. I think there's been, and I know I've written a number of stories about foster care and what some of these young people have gone through. I think they're great stories of human resiliency and young people who have overcome amazing odds. And I think even if I were in that situation at that point in my life, I dare think what would have happened to me. But there is a lot of sensitivity as well, and including not just children when they're children, but I recently, within the last year, did a story on the COSAs, the court-appointed special advocates, and the really heroic work they're doing in San Francisco. And they gave me several young people, former foster youth, who agreed to be interviewed. One was 19 years old, and I'm interviewing her, and in the course of things, she mentions, by the way, my father, not her biological father, but the father who was caring for her, is in prison for 60 years. And she goes, you wrote about it, his case, when it happened, when he was sentenced in the Chronicle. Turns out when she was abused from the time she was 8 years old. At age 12, when she was 33 weeks pregnant, the abuse was discovered. Her father was sent to prison in what the judge called the worst case of child abuse he'd seen in his life. And at that point I'm thinking, I can't put this young woman's name in the newspaper, 19 years old. I mean, every time everybody Googles her from here to the end of time, they're going to find out about this, horrible abuse she went as a child. And I actually had a fairly significant talk with her about that in terms of what the consequence is of being that public, even though she's obviously gone past it. She looked at me in the eye and said, look, I graduated from high school. I am going to City College and working and supporting the child who, it was her guardian's child, while she's going to school. She goes, I've overcome all this. I want my story to be told. I want to remove the stigma. So just because we identify, there are obviously, there is a stigma sometimes with the abuse that young foster youth have gone through, and I don't think you would find, certainly my newspaper, the LA Times, or any reputable newspaper or organization is going to be identifying these young people by name or even identifiable information. It becomes a little more complicated if you're in a small town. But I think to not tell these stories and to humanize it one-on-one is to just lose this issue in a blur of statistics, and I don't think that engages the public.
Do we want to take, Leslie, do you want to jump in, or do we want to take a question? You can...
I just, real quickly, I don't know. I think that's exactly the point, though, is that this particular young lady wanted her story told and wanted to be identified with her story. And we need to be sure that if the next young lady in the same circumstance doesn't want her information out there, that it's not going to be. So I don't disagree that people who want to be covered should be covered, but those who don't, the youth who don't, we feel shouldn't have to be, and the question then becomes putting the burden on them to prove why they shouldn't have to be, rather than making it a choice. And I think on the point about the quality of coverage and what is covered, I agree there has been coverage that shows resilient youth, but that is very positive for the youth, and it highlights their strengths and their ability to overcome within their personal situation. But I don't see the connection between how that will then give us as the system, and I'm going to include us as advocates in the system, even though I'm not sure we always, I mean, I think there's some gray there. Sometimes we're fighting the system, and sometimes we're viewed as part of the system, so I'm not sure which we are 100%. But I don't know how that highlights the needs of the system to do a better job for the youth who aren't as resilient as the individual, who may be featured in a particular story. And we, of course, commend that type of coverage, but it begs the question of how the story after story about this is a terrible, horrible system that does no good is going to make the system better. And I'll give two really quick examples. After one of the first articles in the past year came out, we got a phone call from one of our largest donors asking if he was making a mistake with his money. We've been telling him all these good things about all the good work our lawyers do, and now he reads this article about a particular case where everybody was sort of laid out as not doing a good job, and maybe it wasn't a good place for him to be investing, as it were. Fortunately, we were able to talk him off the ledge, but we don't know what others might be negatively impacted in that way as well. So the balance of coverage is something that we hope we will see more of, to highlight the need instead of just the problem. We need a solution in there somewhere.
Well, let me just ask you, do you think these donors or people, in terms of public support, are going to be more inclined to be supportive or you're more inclined to get contributors if they have no idea what's going on in that courtroom? Certainly, I think part of the story, as we told in ours, when you go to these child dependency courts, you see the workload, you see these snap judgments that have to be made. I think that makes the argument for more resources.
If that's what's reported, but I'm not sure that that's what's been reported yet. So maybe
Okay, I'll give you a copy of
it's
ours.
okay. I don't want to argue about it.
I think also the case of individual resilience among youth was definitely leveraged to push through extension of foster care, not only on the federal level. That whole narrative about transition age youth really gave the advocates, I believe, some kind of strength when it went through Congress and made it all the way through, and then down here in California too. So I do think that the fuller picture does have, and otherwise I would have no job, but I do think that the fuller picture does have an ability to impact policy. We've got a question here.
Yeah, my question comes more about accountability and the big thing with confidentiality faced foster youth. Here in Alameda County, for instance, our 241.1 hearings are open, are determining for 300 or 600 status. But let's say there's the big problem in Alameda County is sexually exploited minors. So let's say you publish a story about a sexually exploited minor, pimp finds her through the story, beats her up or hurts the child. Who's held accountable?
Right.
So who is the journalist held accountable? The courts held accountable? The social workers held accountable? So that's my question. How do we have that accountability for journalists?
Let me give you my quick answer, and then I'm sure others will weigh in. But I like Judge Nash's standards. Although he didn't use this term, I would say he basically has a presumption that the press has a right to be there unless there could be damage to the harm to the child. And I think that's a case where the attorney or social worker should step in and explain exactly what you describe as a possibility of happening could happen.
Let me just also say, and I agree with that, but in that situation, which would be unfortunate, so is it the reporter's fault? I mean, we have a system that's designed to protect the child, okay? Whether we report it or not, it's the system's obligation to protect the child. So if something bad happens to the child in that framework, then the system's not doing its job. It's not the reporter's fault. The reporters are saying, this is the situation, okay? And if that could have that negative result, but at the same time, the rest of us have an obligation to protect that child. And if something bad happens, I don't blame it on the reporter, I blame it on the system.
Well, I would argue a little bit further. I would say it is not the responsibility of the reporter to not go in there and I mean, the thing is, the stakes are so, if I write a story about a kid and they end up in a bad situation because of what I wrote, it's their life on the line, it's not mine. And so I think that, you know, what your question about accountability, and I don't know the answer to that. I don't think you can say, there are jurisdictions that have contempt, right, as a remedy if you were to divulge information about that child. But I don't really know the answer to that question. There's Chantel's got some that jump in too.
Well, two things that I prompted my response. I think the first thing is that I think what we're talking about is that the youth is held accountable, but it also should be the judge's responsibility. The judge is the parent of the youth. I mean, none of us would allow, those of us who are parents would never allow our child to be subjected to that. The court is the actual parent of the child.
Does the reporter have to report to the court before they write the story?
No.
Remember if I could
Jump in.
in the time, again, over this past year that I've been attending with some regularity, there have been a number of objections by lawyers for children to my presence for one hearing and another. And whenever that's happened, actually, I think in one case it was overruled, but in every other instance, the objection was sustained and I left. But beyond that, I think you should give us some credit here too. I mean, I'm there in proceedings where there's a great deal of detail provided. And so even if I didn't give a child's name, there's the possibility that I could provide enough detail in the story that someone who knew the child could identify that person, the family circumstance, the particulars of the whatever the case. And I'm writing those pieces deliberately not to do that. And I think that that's the way, I'm sure John and his colleagues at the Chronicle, I think that's the way most responsible reporters will handle this. One other thing, though, there has been a number of instances where lawyers have said, if he's going to be allowed to attend, Judge, will you at least order him not to use the name of a child? And we have, I personally, and I've been accompanied by a lawyer on a couple of occasions, have objected to any such order as a restraint on our reporting. If I'm there lawfully, that I should be allowed to report what happens in front of me. Now, ethically, I'm not going to do that. So we're engaged in some fairly protective judgments here that we normally, that are sort of beyond our normal decision making at the paper. But there is thought going into this. We aren't just showing up at hearings and publishing names in the paper willy-nilly.
Yeah, Chantel, you can finish your thought.
Sorry. I really like the situation you brought up because for those of you guys who don't know, 300 is child welfare, 600 is delinquency. And so I think that's a really good example of what we're talking about here. So if that same child falls over to the delinquency side, they're still protected. Nobody is sitting here talking in this here about delinquency. Nobody wants to open delinquency courtrooms. We're only talking about the victims, not the alleged perpetrators. And so they're treated kind of unfairly.
What about the delinquency side? Does anybody have any thoughts on that?
One of these days I'll get around to crafting the same order to apply to the delinquency court. I haven't because it's, one step at a time, plus the delinquency court is a lot more open already than the dependency court by law.
Joseph?
I'm a little concerned about the framing of all of this, that somehow bringing the media into the courtrooms is going to be the panacea, is going to shed that light, and that perennial problems of the system, beyond bringing the media into a courtroom where youth and children are already at heightened vulnerability. It's not the safest and most comfortable place. And their whole story is being told in a way that maybe they don't have much control over it. I think we have to acknowledge the consideration. I just wonder if folks on here have other ideas about ways to shed light into improving the system, because I think we're all on the same team here in terms of recognizing the system isn't working, it's failing our children, there are gaps. For those of us in the industry, we know that we need more resources, that lawyers have huge caseloads, that social workers have huge caseloads, that there are problems. I'm just not convinced that bringing a journalist into a situation where it is at the pinnacle of vulnerability for that child is going to change that. And there are other ways to do that. I'd be curious to hear, I have some ideas, but I'd be curious to hear what you folks think of ways in which the system can be improved without using the vehicle of the courtroom to be the only place to shed light.
Let me just say this. You used a word that I think really doesn't apply here, panacea. There is no panacea. Okay, if there was a panacea, we would have thought about it a long time ago. Okay, the fact of the matter is, many of us have been and continue to work in many different ways and have done so for a long time to try and improve the quality of this system. It includes advocating for more resources. It includes doing better education for our judges, better education for our lawyers, better education for our social workers, giving folks more tools to do what they do. So there's all sorts of ways. Adding the sunshine, if you will, to the courtroom, it's not the panacea. It's something that can help. It can help in certain cases and in certain instances, and there are times that it hasn't, and there are times that it has. So it's just one other tool in the tool chest that is designed to hopefully bring about a better system. That's all. It's not the panacea.
We have Phil.
I would thank you all for being here and talking about these issues. The thing I love about this is it's two groups trying to decide the best way to help children. And I think we're never going to come to consensus if we think that there are different ways to help children, because we're both passionate about doing that. What I would suggest is that the debate isn't about journalists in court or journalists out of court. It's about the rights that we're trying to protect. Right now, children have a constitutional right to privacy, period. So how do we protect that? Now, when you look at how to protect privacy, privacy is not an absolute thing. You can pierce it, you can print things in the newspaper and still not, get sued for it. I would put to the panel, if you've given any thought about how to protect children's privacy rights if you are going to allow journalists into court. And I would say that this is important because you have a situation, and this is the whole debate really, you have a situation where a judge brings a child or a child's case into court specifically for the purpose of talking about all of the rights that are subject to a privacy right, whether the child is sexually active by choice or by not, whether the child has mental health issues, whether they have health issues, you name it. The things that are going to be talked about in court relate to the right of privacy, period. And we know that they have a right to privacy for much the same case law that exists in California. So because children are being dragged there to discuss privacy rights, how do we protect it when you have a journalist who has a constitutional right in California to print what they hear? How do you, balance these rights? One suggestion I might have, and I think there are others, is that you can sue someone for public disclosure of private facts. Why not make that strict liability for foster youth when it comes to name or certain identifying facts? Why not make it so that the press are free to publish whatever they want at a cost? That there's a set harm, we set a certain dollar figure for kind of liquidated damages for publishing a foster youth's name. And we say that it's strict liability. If you publish a foster youth's name, then you will be liable for this minimum amount. And I will say this other thing, that when you're talking about this sort of public disclosure of private facts, consent is an affirmative defense. So if you have a foster youth consent to publish these things, then you're going to per se not be liable. But if we can identify certain things to control either newspapers who publish or journalists who write and then publish somehow, if we can control their actions through other means, I think that's important because thinking about this journalistic ethics, it's nice and I like it. However, if it's unenforceable, it's unenforceable. In a world where Britney Spears has children being brought in to dependency court, there's no way to enforce that sort of ethical guidelines that journalists are just going to want to adhere to instead of being enforced. So I'd put that to the panel.
Barry?
Yeah, I guess I want to throw a little monkey wrench into this conversation because I think our tendency is to focus in on courtrooms. Same thing in the criminal justice system. Even though the vast majority of cases never get to a courtroom, we spend all our time obsessing about what happens in front of jury trials. One of the major issues in child welfare is how the invisible decisions that are being made all the time. Very small percentage of cases referred to Child Protective Service even get investigated. The intensity of that investigation, whether or not charges are brought, all of this well below the surface. And I think a lot of us are convinced that, you know, you probably, no matter what you do in the courtroom, you're not going to fix this hidden below the surface system where lots of discretionary decisions are being made all the time. You know, one good example is racial disparity. The child welfare system is far more racially disparate than the juvenile justice system or the criminal justice system. Yet, it's hard to get our hands around that. Criminal justice system is pretty good at collecting data. We know how many people are arrested, we know how many people are charged. So again, I would urge that a lot of the reforms that need to be addressed, where the media could do a good job, is to penetrate this invisibility of the system.
Could you guys talk a little bit about how within the profession, the journalist code of ethics are, you know, created, inculcated, and enforced between journalists?
That's a good question. Well, I can tell you, I don't know if I can answer that for the profession, but I can tell you a little bit about how we did it at the Times. 2001 or 2002, I think it was, we had an old set of guidelines that felt antiquated. The then editor of the paper, John Carroll, convened a group of senior editors to review those guidelines and sort of update them. I was brought in to be the sort of you know, stenographer of that process, and I ended up being the principal author of them. But they really reflect John's sort of values more than anyone else's. But it was a serious project over many months at the paper, involving all of the most senior people on the editorial side. There is no specified enforcement. It doesn't say that if you rat out an anonymous source that you will be fired. But that's happened. I've seen that. I mean, I had a personal experience with a reporter who fabricated some information, and we put him through a torturous review, and eventually, when it was clear that he wasn't telling the truth, fired. It doesn't happen every day, thank God, but it does happen. They are taken seriously. The guidelines do have some specific language about children and about victims of sexual abuse and others. We very rarely in the guidelines say that you will never do something, because there are instances where, I can give you one example. I covered the allegations against Michael Jackson years and years ago, went on for months. And throughout it, Michael Jackson's legal team argued that we were improperly withholding the name of the alleged victim, because their contention, of course, is he wasn't a victim of sexual abuse, he was trying to blackmail Michael Jackson. Well, we never did release that name. We protected it very carefully. And so there are moments where this is a matter of some tension, but at every instance, and certainly every instance that I've been involved in, they've been taken very seriously, and violations of it are taken very seriously. Now, I don't know, as I say, whether that speaks for the whole profession, but it certainly does for the Times.
Yeah, I think that's also true at the Chronicle and most institutions, is that we do have a set of written guidelines on ethics. For example, not identifying a victim of sexual assault or abuse, not identifying juvenile suspects. But at the same time, it becomes situational. If you have like a triple homicide, you know, at what point involving a juvenile suspect, do you then, you know, release their name? And there's always a great deal of discussion, usually at pretty high levels, when you're going to veer from any of the guidelines that you have. I think in the case of if there was a presumption on of openness on dependency courts, I mean, we haven't been in there enough. I mean, the time that I described was really an exception, because the courts are not open in this area. But when we do, I suspect if we were allowed in on a regular basis, there would be, you know, some written into the guidelines. And in terms of the enforcement, I really don't think you could have a law that had either civil or criminal penalties against a journalist for disclosing any information, particularly in I'm probably getting in dangerous territory here. I'm at the law school, but I'm confident that our attorneys for the Hearst Corporation would vigorously defend on First Amendment grounds, you know, our right to publish any information that happened in any public proceeding. You know, you do have a conflict of rights between a right to privacy, which in California is explicitly embedded in the Constitution. It's an implied right in the U.S. Constitution, versus the First Amendment, which is also a very, you know, fundamental, the First Amendment of the Bill of Rights, but it's not absolute either. So I really think the judge here has come up with a very good solution, which I would suggest, and you may see in our paper in the next few days, might be a template for the legislature to look at to resolve this issue.
Well, once again, you know, talk about your right of privacy and all that stuff. There is no absolute right of privacy that I'm aware of. And you did the research. Are there any states would say that the dependency court is closed, it's airtight closed, nobody could ever come in? I don't know if that's the case.
I think there's one or two that don't mention a standard for openness, for opening it, but I don't know what the courts have done.
Right, and you know, here, we're in California here, and our law is not absolute in California, as I said. Number one, if the child says okay, the law says you can come in. But the next sentence says, despite that, essentially, the court can let somebody in. And so the question is, what standards are we using? And once again, I agree with you that what I did was looked at the case law and the language of the statute and attempted to set a standard that makes some sense and is consistent with the law. And at this point, I have to say that there hasn't been one individual anywhere that has convinced me that that is wrong. And there were plenty of opportunities for folks to do that. And the Court of Appeal, you know, hasn't done anything specifically except, you know, deny the request to eliminate my order. I think that order is a template. I don't think the law in the state needs to be changed at this point. I think all that has to be done is people need to look at it and understand exactly what I said, exactly what I did, and then I think it protects the children and is consistent with the law of this state. So yes, I'm surprised that there are no other jurisdictions around the state that have adopted a similar process that we have done in Los Angeles, because I think it's totally consistent with the law that exists.
Sephora, in the back.
What in the case of one sibling, where there's multiple siblings consent, but such as saying my brother doesn't, what would you do in that case? Would you still go on and give permission, or what could be done?
Well, that's just one consideration in deciding whether or not whoever is there is allowed to be there. If it's the press, then once again, that's not the test. The test isn't consent of the child. The press has a legitimate interest. And so the only question is whether someone can show that their access is going to be harmful to any of those children on the case. And somebody has to, you know, actually affirmatively show that.
But wouldn't that just go into the child's privacy, where the one doesn't want consent?
Well, once again, everything goes into the child and everybody else's privacy that's involved in our proceedings, but the privacy is not absolute.
We've got one question here.
So I've been through the system twice as a relative caregiver who ended up adopting 2 great nieces out of foster care. And I just want to go back to what Mr. Chrisberg said about the overarching system, because I think there's an inconsistency here, which is if you go to Alameda County and you sit in the hallways, there's no privacy. These cases are discussed, children are interviewed, they are meeting their attorneys for the first time, sometimes awesome attorneys who are running to meet with them before a hearing. I've received calls from attorneys at 10 o'clock at night saying, wake up the 5-year-old, I need to talk to her before court tomorrow. That's how busy people are. So to me, there's an inconsistency, which is either we protect our privacy, because if you're a reporter, you could get one whole side of the story out in the halls. Yeah. And you come into the courtroom and you hear an abbreviated version of a report that somebody's given, and you see how quickly things go wrong. In my case, some real injustices happened. They were corrected over time. The system worked itself out. But there was, what was happening in social worker visits, there was what was happening in the courtroom, there was what was happening in the halls of the courtroom, and to focus just on what's happening in the courtroom as if that's the sacrosanct place where we need to have privacy, is just not what the reality of the system is. There isn't any privacy.
Well, but once again, we're focused, on the courtroom, because that's a place that's generally been off limits. And the bottom line is There is a lot that happens in that courtroom. There's a lot that can be learned from watching what happens in that courtroom. And there's a lot that happens in that courtroom that has a profound impact on everybody involved with that case, from the child to the parent, to the relative caregiver, to the social worker, to the attorneys, everybody. And so it's not something that we should just take lightly. But I agree with you that there are so many other aspects of the system that need to be explored and examined in much more detail than they are today.
And I think also, just generally speaking, the interest in the courts, from my perspective, is really more a wedge into a broader conversation about system that is cloistered more than other systems, and I think that that's got its detriments. I think we're going to have 2 more questions. Yeah.
I think we should go over the code of ethics a little bit, because I don't think everybody's reviewed what we're talking about today.
Well, I think everybody can. I think we're running low on time, but I think it's. I mean, I would love
just a minute.
Yeah, just a minute. I mean, Lily's got the right idea. Basically, the idea with the code of ethics is, if you go through it, is to create a standard by which, in those jurisdictions where you don't have activist judges who have created standards, some kind of standard wherein a journalist could access the courts more easily. We've done that in 5 jurisdictions, and we've been granted access, I think, quicker, because we have said we will not disclose these facts. We will announce ourselves. We will do these certain things that show a certain level of responsibility. And barring a big news organization behind many journalists out there, at least it provides a framework to work forward from. So that's as far as the code of ethics goes. And I'll have 2 more questions. Darren?
The problem that I've seen over my 25 years doing this, both as a dependency counsel and as a civil litigator going after municipalities for the allowing neglect and abuse of children, is that there is an inherent conflict of interest of the social workers and even minors counsel when problems come up that's their fault, or that they've overlooked, or that they haven't addressed effectively, or they didn't make sure that the doctor's appointments were done correctly, or that certain abuse that was happening wasn't noticed because they didn't visit as required. And what happens is the conflict of interest is to either expose it to the judge and to the courts so that it is addressed, or to do what you can to keep it, maybe there'll be an internal memo, maybe we'll do it behind the scenes to take care of it. And the only time that it ever comes to the press, to the public attention, is when there's a death. And that's the fact. And the problem is that just like when we drive down and we drive the speed limit, even though there's not cops around, because we don't want to get that ticket just in case. If we know the press can come in, not whether they will on a particular case, but we know that they can come in, the social workers, the attorneys, the judges, everyone there is going to be much more accountable and much more reliable and much more careful for what they're doing. And that's the importance of the press, in my opinion.
Leslie?
So I think I think the media wants us to assume that they are good actors with good intentions, and I think we want the public, the media, whomever, to assume that we are good actors with good intentions. Very few people become social workers or minors attorneys or COSAs because they want to ruin children's lives or hurt their families. And in your example of a conflict of interest and some idea that we would try to cover up our neglect of our client, we're required under 317E to notify the court of anything that is contrary to our client's interest and any possible outside litigation that might exist for them. And at least in jurisdictions where there's organizational representation, I'll put in a plug for organizational representation, because children can't assess the quality of the representation they're receiving, and that's why lawyers for children should have supervisors and directors and courts looking at what they're doing. If I'm going to cover up something that's happened to my client, the media's not going to know about it either. But to the contrary, we're required under 317E to file a report and to access outside counsel to sometimes sue us, and it happens. But we can't make rules assuming people, whether it's the media or the advocates, are coming to this with bad intent. I mean, I'm assuming that we are all that we have to make rules and laws and procedures and protocols and issue blanket orders with an overlay that the various actors are coming to their work with a responsible, ethical approach. And it would be unethical to hide from the court something bad that happened to our client, whether it was our fault or not. So I don't think that should be our starting point, I guess.
And can I just have a very brief note to that, which I agree, but I also would say that the court is a good place to hear people complain about the services they're getting in foster care. The most common things I hear is children complaining that their social worker didn't show up to take them to a doctor's appointment, or didn't get their things moved from one house to another. So it is, as Judge Nash indicated, it's not the whole system, but it is a nice place, or important place, to be able to observe just the kinds of complaints, not necessarily the conflict that you're describing, but at least the underlying complaints that might be there.
Okay, we'll have, Chantel.
Just really quickly, I believe we're going to continue to hear those complaints until we actually fix what we already know is the problem, that our social workers and attorneys are way overburdened and their caseloads are too high to be able to serve the children in our foster care system.
And, you're right. And I would be nothing if not an idealist, but I do think that down the line, if we had really diligent coverage and diligent looking at this system, at the heart of really all these other systems that are hurting across the board, we at least have a chance at doing something. So I think that's the reason behind focusing this attention on it, because it's a place where all those other things intersect. And if we can get it right there, maybe we got a shot. But we got to get it right there. And we need everybody, as Judge Nash said, to help. And I think that a responsible media is probably a pretty strong person to have in your corner. We're going to end with David Colby.
Yeah, I was just basically wanting to say that I know that the media would only go in the courtroom for specific circumstances, such as my own. That the court was trying to denying me foster care, even though there was a law that said that I was still eligible to continue foster care. But basically, that was my experience. But anyway, like I said, the media going to the courtroom it is complicated. I really hope that we get this issue settled out between the right to free speech and the right to privacy. That way we'll be able to have a mutual agreement and everything will be well. But I really hope that the children in the future will not suffer anything, complications or anything.
Thank you, David. And David's story was helped fix up that funding gap for 2,177 other foster youth in that same position. So, thank you for sharing that story. If anybody's got any closing thoughts,
I do.
Yes?
I guess in terms of the code of ethics and ways that the media can help us all reach our goals for a better system. I guess my closing request would be that as we approach this, let's figure out a way to do it to not make it harder for us to do the work we're trying to do on behalf of the children and families that are coming before the court. And if there's ways to do it to make it, less, not to make our jobs harder. The lawyers, the social workers, the judges already have very full plates, and we need to be able to focus on the core, our core mission, which is protecting the children and serving their families.
Just one quick thought, Daniel, to leave you with is when we talk about media access to courtrooms, we're not talking about special access for the press. I think the judge has laid it out in his policy. Others who have a legitimate interest should be allowed in as well, and that could be, it could be a children's advocacy group, it could be a neighbor who's concerned about what's going on. When I look at foster care, there's a mantra that we use in the San Francisco Chronicle when we write about this issue and try to engage readers. These are our children, our collective responsibility. I think the public has a right to know what's going on with them. Thank you.
Lily?
I think that our differences are a lot smaller than what we agree on, and I think we all can agree that we don't want stories published about young people who don't want stories published about them, and that the code of ethics as well as the rules are kind of intended to protect against names getting out there, and so I'm glad that we all have that on our side, and I think that we've kind of agreed that sometimes the media can sometimes provide some information to the public that can sometimes change laws. And so as a closing thought, all of us advocates should stay in touch with some of these media people when good things, bad things, interesting things are going on, so we can make changes and provide public support for those changes on Capitol Hill, because we don't have the money, we got the stories. Okay, thank you.
Chantel?
Yeah, I think this was a really good start on what we see as a complicated issue, and I do think that we are close in that we all want the best interest of children and youth in foster care. I think that's what we all agree on as of now, but I would just urge, the media and all the child advocates, I know we stand on different sides, but I think where we can really use journalism and the media's help is that we do know what's wrong with the system. I mean, if you went, the Blue Ribbon Commission on Children in Foster Care produced a report 4 years ago. We keep publishing the same reports over and over and over, telling us what is wrong with the system. So if journalists in the audience and on this panel want to help youth, I think we should start in seeing how we can all work together to make those become a reality.
Dave, nothing? Mary? Nothing? Okay, guys, thank you very much. I appreciate your time and your thoughts. Thank you to our panel. Thank you.
Comment.
Yeah, thank you.